Hello friends. Today we are discussing about one of the most foundational topics in Indian civil litigation, how a civil suit actually works, from the moment you decide to file it to the moment the court pronounces its judgment. Now this is important not just for lawyers but for every common person because civil disputes, whether about property, money, contracts, family matters or service, are an everyday reality in India, and understanding the process gives you a decisive advantage. We are going to cover five essential pillars today. First, the concept of jurisdiction and why filing in the wrong court can be fatal to your case. Second, limitation, why time is your most unforgiving opponent. Third, court fees, because you cannot even enter the courtroom without paying the right amount. Fourth, the three stages of a civil suit from start to finish. And fifth, the critical process of service of summons and what happens when a defendant tries to evade it. Let us begin. The very first question before you file any civil suit is this: which court has the power to hear your case? This is called jurisdiction, and it is governed by the Code of Civil Procedure 1908, commonly called the CPC, along with the Specific Court Fees Act and the relevant state acts. Jurisdiction under the CPC operates on three axes. The first is territorial jurisdiction, which means the court must be located in a place that has a geographical connection to the dispute, typically where the defendant resides, where the property is situated, or where the cause of action arose. Section 15 to Section 20 of the CPC govern this. Section 20 in particular is extremely important. It says a suit can be filed where the defendant actually and voluntarily resides or carries on business or personally works for gain, or alternatively, where the cause of action wholly or partly arises. Now, here is where most people make the first fatal mistake. They file where it is convenient for them, not where the law says they must file. A suit filed in a court without territorial jurisdiction is liable to be dismissed or returned at any stage, even after years of litigation. The second axis is pecuniary jurisdiction, which means the monetary value of your dispute must fall within the financial limits of the court where you file. Every court has a pecuniary ceiling. A civil court at the municipal level handles disputes up to a certain amount. A civil judge handles a higher range, and above that comes the district court or the high court's original side. Filing a claim worth 50 lakhs in a court whose ceiling is 10 lakhs is not just a procedural error. It means the court has no power to grant you the relief you seek. The third axis is subject matter jurisdiction. Certain courts simply cannot hear certain types of cases regardless of the amount involved. Probate matters, company law disputes, matrimonial cases, and insolvency matters all have special courts or tribunals. If you file in the wrong forum for subject matter, the suit is a nullity. Always get the jurisdiction right before you file. The Supreme Court and various high courts have consistently held that jurisdiction goes to the root of the matter. It cannot be conferred by consent of parties if the law does not permit it. Once you know the right court, the next thing you must understand before filing is limitation. And this is perhaps the single most important concept in civil litigation. Limitation is governed by the Limitation Act 1963, and it prescribes fixed time limits within which every civil suit must be filed. Miss that window, and your suit is barred forever, no matter how strong your case is on merits. The general rule is in Section 3 of the Limitation Act. Every suit filed after the prescribed period shall be dismissed even if limitation has not been pleaded as a defense. Now, what are these periods? For a simple money suit based on a contract, the limitation period is generally 3 years from the date the cause of action arises. For suits related to immovable property, the period is 12 years. For suits to recover possession based on title, it can extend to 12 years from the date of disposition. For suits based on a mortgage, it can be up to 30 years in certain situations. Now, the critical question is always, from when does limitation begin to run? Section 3 read with the schedule to the Limitation Act prescribes this precisely for each category, but there are important exceptions. Section 5 of the Limitation Act allows a court to condone delay, that is, to excuse a late filing if the applicant can show sufficient cause. However, Section 5 does not apply to suits. It applies to appeals and applications. For suits, there is no general provision to condone delay once the limitation period is gone. There are, however, doctrines that can save you: the doctrine of continuing wrong, which holds that where a wrong is of a continuing nature, a fresh cause of action arises every day. The doctrine of acknowledgment under Section 18, where a written acknowledgment of liability signed by the party resets the limitation clock. And Section 19 on payment, where a part payment by the debtor before expiry also extends the limitation period. The Supreme Court has time and again held that courts must apply limitations strictly. A meritorious suit filed one day late is as dead as one filed 10 years late. So always calculate your limitation period first before you do anything else. Now let us come to court fees, which is a practical barrier that many people underestimate. Court fees in India are governed by the Court Fees Act 1870, along with individual state court fees acts, and most states have their own legislation that controls this. In West Bengal, for instance, the Bengal Court Fees Act 1922 is the applicable law. Court fee is essentially the stamp duty you pay to the government for availing the judicial process, and it is paid in the form of court fee stamps affixed to your written complaint to the court. The amount of court fee depends on the relief you are claiming. For suits where you claim a specific sum of money, say recovery of dues under a contract, the court fee is ad valorem, meaning it is calculated as a percentage of the amount you claim. For suits relating to immovable property, court fee is calculated on the market value or the claimed value of the property. For suits seeking injunctions, declarations, or other non-money reliefs, court fee may be a fixed amount or calculated differently depending on the applicable state act. Why does this matter so much? Because if you pay insufficient court fee, the court will reject your plaint or issue a notice requiring you to make up the deficit within a time period. Under Order 7 Rule 11 of the CPC, a plaint can be rejected if the plaintiff fails to comply with the provisions of Section 149 CPC, which is the provision for making up deficient court fee. Now here is the important thing. Even if you file within limitation but pay the wrong court fee, and if by the time you correct the court fee, the limitation period has expired, the courts in India generally take the view that the suit was validly filed on the original date for limitation purposes, provided you comply with the court's order to pay the deficit fee within the time allowed. The Calcutta High Court and several other courts have followed this position. So pay close attention to the court fee calculation at the time of filing itself. Get it right from day one. Let us now come to the three stages of a civil suit and map them onto the specific provisions of the CPC. Once your plaint is filed with the correct court, correct jurisdiction, within limitation, and with proper court fee, the court formally registers the suit and a suit number is assigned. The first stage, which I call the interlocutory stage, is actually a cluster of several preliminary proceedings under the CPC. The court first examines the plaint under Order 7 to satisfy itself that it discloses a cause of action, that the parties are correctly named, that the relief is clearly stated, and that the court fee and limitation appear to be in order. If the plaint is in order, the court issues a summons to the defendant under Order 5 of the CPC, directing the defendant to appear and file their written statement. The written statement is the defendant's formal reply to the plaint governed by Order 8, and it must be filed within 30 days, extendable to 90 days from the date of service of summons under Order 8, Rule 1, as amended. During this stage, the court also takes up any application for interim or interlocutory relief, the most common being an application for a temporary injunction under Order 39, Rule 1, and Rule 2 of the CPC, where the plaintiff seeks an urgent order restraining the defendant from doing something that would cause irreparable harm pending the final disposal of the suit. For a court to grant a temporary injunction, it must be satisfied of three things. First, the plaintiff has a prima facie case. Second, the balance of convenience is in the plaintiff's favor. And third, irreparable injury will be caused to the plaintiff if the injunction is not granted. These three conditions were classically laid down by the Supreme Court in American cyanamide principles, adopted in Indian courts and reiterated in numerous judgments, including Gujarat Bottling Co. Limited v. Coca-Cola Co. Once pleadings are complete, that is, once the plaint, written statement, and any rejoinder are on record, the court frames the issues under Order 14 of the CPC. Framing of issues is the formal identification by the court of the exact questions of fact and law that need to be decided in the case. This is the close of the interlocutory stage and the gateway to the evidence stage. The second stage, the evidence stage, is where the real contest begins. Each party leads evidence in support of their case. Evidence in a civil suit is of two broad categories: documentary evidence, original documents, agreements, correspondence, title deeds, financial records is produced, exhibited, and marked by the court under the Evidence Act. Witness evidence, oral testimonies of the parties and their witnesses, is recorded under Order 18 of the CPC. The examination in chief of a witness is usually done by way of an affidavit in most courts today, and the opposing party then cross-examines the witness in open court. This stage can be lengthy depending on the number of witnesses and the complexity of the documentary record. Once both sides have completed leading their evidence, the court formally closes the evidence and the suit moves to the third and final stage. The third stage, the peremptory hearing or final arguments, is where the advocates for both sides make their complete oral submissions before the court. The plaintiff's advocate argues, first, taking the court through the pleadings, the evidence on record, the applicable law, and the reasons why the relief claim should be granted. The defendant's advocate then responds, challenging the plaintiff's case and arguing why the suit should be dismissed. After hearing both sides, the court may pronounce the judgment immediately or may reserve it, which means the judgment will be delivered on a later date. Under Order 20 of the CPC, the court must deliver judgment within 30 days of conclusion of hearing. extendable up to 60 days in exceptional circumstances. The decree follows the judgment and is the formal expression of the court's decision. It is the operative document on which execution proceedings can be initiated if the defendant does not comply voluntarily. Before we close, there is one more critical topic that ties all of this together: service of summons. When a suit is filed and registered, the court issues a summons to the defendant directing them to appear. Under Order 5 of the CPC, this summons must be served on the defendant personally wherever possible. Personal service means the summons is handed directly to the defendant and they acknowledge receipt. But defendants often try to avoid service, they refuse to accept, they remain absent, or they become deliberately untraceable. The law under Order 5 Rule 17 provides that if the defendant or their agent refuses to accept service or cannot be found after due diligence, the serving officer can affix a copy of the summons on the outer door of the defendant's last known residence and make a report to the court. This is called substituted service. Under Order 5 Rule 20, if ordinary service is not reasonably practicable, the court can order substituted service by affixing the summons at a conspicuous place in the courthouse and also at the defendant's last known place of residence or by newspaper publication. Once such substituted service is ordered and complied with, service is deemed complete and the case proceeds. The defendant cannot later claim they were never served. It is also now common in Indian courts, following the Commercial Courts Act and amendments to the CPC, to allow service through electronic means, including email, WhatsApp, and courier in appropriate cases. Understanding service is critical because the entire downstream timeline of the case, when written statement is due, when issues are framed, when evidence begins, all flows from the date of service of summons. If there is a defect in service, it goes to the root of the proceedings and can even vitiate a decree passed ex parte against the defendant. Always verify that the defendant's address in the plaint is correct, complete, and current. This is one of the most common but most avoidable causes of delay in civil litigation. Subscribe to our channel to get this kind of more updates.